Hello friends, we are now going to discuss the polity and constitution questions which appeared in Prelims 2018. As you can see the questions on your screen, the first statement of first question is, in the first Lok Sabha, the single largest party in the opposition was the Swatantra Party. This statement is wrong because the single largest party was the Congress Party, and in opposition the largest party was the Communist Party. So this statement is wrong. The second statement is, in Lok Sabha, a leader of opposition was recognized for the first time in 1969. This statement is correct. Third statement, in Lok Sabha, if a party does not have a minimum of 75 members, its leaders cannot be recognized as a leader of opposition. This statement is wrong because the leader of the opposition party, the largest opposition party, needs to have at least 10% seats, which comes out to be 55 seats and not 75. Therefore, out of the three statements, only statement 2 is correct. Hence, the answer is option B. We come to the next question. The Parliament of India can place a particular law in the 9th schedule of the Constitution of India. This statement is correct. The 9th schedule and the Article 31B were inserted in Constitution by the First Amendment 1951. It empowers the Parliament to place certain laws inside the 9th schedule. Second statement, the validity of a law placed in 9th schedule cannot be examined by any court and no judgment can be made on it. This statement is wrong. Supreme Court very clearly and emphatically has said in IR Coelho versus State of Tamil Nadu 2007 case that all the laws kept in the 9th schedule after the date of judgment of Keshavnanda Bharti versus State of Kerala 1973, and that date was 24th of April 1973. Those laws can be challenged in Supreme Court if they violate the basic structure, and hence the statement 2 is wrong. Thus the answer is option A, that is first statement only. We now come to the third question. It says, the first statement, Aadhaar card can be used as a proof of citizenship or domicile. This statement is wrong, and recently Calcutta High Court has held that Aadhaar card is not a proof of citizenship. Second statement, once issued, Aadhaar number cannot be deactivated or omitted by the issuing authority. This statement is also wrong because the Aadhaar authority, the UID, can deactivate or suspend a person's Aadhaar number. Thus, both the options are wrong. The answer is option D. We now come to the fourth question. With reference to the Parliament of India, which of the following parliamentary committees scrutinizes and reports to the House whether the powers to make regulations, rules, sub-rules, bylaws, etc. conferred by the Constitution or delegated by the Parliament are being properly exercised by the executive within the scope of such delegation? Now, as we know, both the Houses of Parliament have separate committees on subordinate legislation which keep a check on all the rules, by-rules, sub-rules made by the executive in exercise of the power delegated to it by the Parliament. And therefore, the answer is B, that is the Committee on Subordinate Legislation. Next question. As per Right to Education Act, to be eligible for appointment as a teacher in a state, a person would be required to possess the minimum qualification laid down by the concerned State Council of Teacher Education. This statement is wrong because it is the National Council of Teacher Education. Second statement, as per RTE Act, for teaching primary classes, a candidate is required to pass a teacher eligibility test conducted in accordance with the National Council of Teacher Education guidelines. Yes, the statement is correct. Third, in India, more than 90% of teacher education institutions are directly under the state governments. This option is wrong. Hence, the answer is B, that is 2 only. We come to the next question. First statement, the Food Safety and Standards Act 2006 replaced the Prevention of Food Adulteration Act 1954. Yes, the statement is correct because the Food Safety and Standards Act 2006 is an umbrella act which has subsumed within itself many acts including the Food Adulteration Act 1954. Thus, the statement 1 is correct. Second, the Food Safety and Standards Authority of India is under the charge of Director General of Health Services, that is DGHS, in the Union Ministry of Health and Family Welfare. This statement is wrong because FSSAI is an independent statutory body headed by a chairperson who is of rank of Secretary to Government of India. Yes, the Ministry of Health and Family Welfare, Government of India, is the administrative ministry, but DGHS is not in charge of SSSAI. Thus, the statement 1 is correct. The answer is option A, 1 only. We come to the next question. Regarding the money bill, which of the following statements is not correct? Now, this question is kind of incorrect as well as confusing because we all know the definition of money bill is given in Article 110. As per the question statements, we have to find out at which of the option statement is not correct. Here, the option A and option C, both of them are not correct and therefore both of them are partially wrong. The statement A is wrong because it says a bill shall be deemed to be a money bill if it contains only provisions relating to imposition, abolition, remission, alteration or regulation of any tax. If we read Article 110, the subclause 1, then it says that the taxation proposals are one of the type of money bills. Other than that, we have many other provisions in the Article 110 which make a bill as a money bill. And thus in option A, the word only is problematic. Then we come to option C. It says a money bill is concerned with the appropriation of monies out of the contingency fund of India. Again, as we all know that the contingency fund of India is kept at the disposal of the President of India. And therefore, the appropriation of money out of contingency fund of India does not require prior authorization of the Parliament of India. And therefore, the statement is incorrect. But if we read the option C along with Article 110, Article 267 and the Contingency Fund of India Act 1950, then out of option A and C, option A seems to be more incorrect. And therefore, the answer is option A. Now we come to the next question. With reference to the election of the President of India, consider the following statements. First, the value of each MLA varies from state to state. Yes, the statement is correct. According to Constitution, a value has been assigned to the vote of every MLA and that value depends on the population of the state to which the MLA belongs. And thus, the value of vote varies from state to state, and UP being the largest state in terms of population, the MLA of UP has the highest value attached to his vote. The second statement, the value of the vote of the MPs of Lok Sabha is more than the value of the vote of MPs of the Rajya Sabha. Now, this statement is wrong because the value of vote of MPs of Lok Sabha as well as Rajya Sabha have similar value, and their value does not vary depending on whether they are MPs of Lok Sabha or Rajya Sabha. Yes, altogether because Lok Sabha has more number of members, so yes, Lok Sabha overall will have more weightage as compared to Rajya Sabha, but the value of vote of individual MP does not vary between Lok Sabha and Rajya Sabha. Thus the statement is wrong. The answer is 1 only, that is option A. Next question. Consider the following statements. The Speaker of the Legislative Assembly shall vacate her office if she ceases to be a member of the Assembly. Yes, we know that Speaker of the Assembly is chosen from amongst the members of the Assembly. And thus, if the Speaker is no longer member of the Assembly, he has to vacate or resign from his office. Statement 2. Whenever the Legislative Assembly is dissolved, the Speaker shall vacate his or her office immediately. The answer is, the statement is wrong because the Speaker vacates his office immediately before the first sitting of the newly elected Assembly. And therefore, even if the Assembly is dissolved, the Speaker remains in his office and does not resign immediately. The statement is wrong. Thus, the answer is option A, that is 1 only. We come to the next question. Which one of the following reflects the most appropriate relationship between law and liberty? Option A, if there are more laws, there is less liberty. B, if there are no laws, there is no liberty. C, if there is liberty, laws have to be made by the people. And D, If laws are changed too often, liberty is in danger. The most appropriate relationship between law and liberty seems to be option C. That is, if there is liberty, laws have to be made by the people. We all know the famous trinity given by the French Revolution of liberty, equality and fraternity. So in these three trinity, the liberty means that there is an absence of undue restrictions by the state on the rights and freedoms of the people. And therefore, the laws have to be made by the people so that they can enjoy a maximum amount of rights and freedoms. And thus, liberty can be said to be equivalent of the power in the hands of people. And thus, the option C seems to be the most appropriate relationship. We come to the next question. Consider the following statements. No criminal proceedings shall be instituted against the governor of a state in any court during his term of office. Yes, the statement is correct. Article 361 has given an immunity to president as well as governors of states regarding any kind of criminal proceedings against them in any court of law. Statement 2. The emoluments and allowances of the governor of a state shall not be diminished during his term of office. Yes, the statement is correct. This provision ensures that the governor performs his duties of office without any fear or favor or biasness. So the answer is option C. Both statements are correct. Next question. Which of the following are regarded as the main features of the rule of law? First, limitation of powers, equality before law, people's responsibility to the government, liberty and civil rights. Now, as we all know that the crystallization of the concept of rule of law was done by the famous legal luminary of England, Mr. A.V. Dicey. And according to the features given by rule of law by Mr. A.V. Dicey, the option statement 1, 2 and 4 are correct. And therefore, the answer is option C, 1, 2 and 4. We come to the next question. If the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, then option A, the Assembly of the state is automatically dissolved. It is wrong. After the famous S.R. Bomai case, the President of India initially keeps the Assembly in a suspended state. Once the Parliament approves President's rule, the President may dissolve the State Assembly. So statement A is incorrect. Statement B, the powers of the legislature of that state shall be exercisable by or under the authority of the Parliament. Yes, this statement is correct. So the answer is answer B. Let us look at rest of the options. Option C says Article 19 is suspended in that state. No, this is a wrong statement. Article 19, or for that matter any fundamental right, is not suspended during President's rule. Option D, the President can make laws relating to that state. Again, the statement is wrong. Thus, the answer is option C. Next question. Consider the following events. The first democratically elected Communist Party government formed in a state in India. Second, India's then largest bank, Imperial Bank of India, was renamed State Bank of India. Third, Air India was nationalized and became the national carrier. Fourth, Goa became a part of independent India. Now we have to arrange these events in a chronological sequence. The first statement, that is the first democratically elected government, Communist Party government, it happened in the year 1957 when we had the second state assembly elections. The second statement is regarding the Imperial Bank of India, which was renamed as State Bank of India. This happened in 1955. Air India was nationalized in 1953. And Goa became part of India after Operation Vijay, and we took it back from Portuguese in 1961. So if we arrange them in a chronological order, the answer is option B. That is 3, 2, 1, 4. The last question. Right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? Now, as we all know, Recently, in 2017, Supreme Court in Puttaswamy versus Union of India 2017 has held that right to privacy is a fundamental right under Article 21 of the Constitution. And therefore, the answer is very clear, and that is option C, that is Article 21 and the freedoms guaranteed in Part 3rd. Thank you.